lots. This proposal for the rezoning and the allowance to permit the reduced setback of 2.4 meters will be giving the new owners the ability to build closer to our property than what is normally called for with respect to an R2 zone. By doing this, we will be opening our back door to their front door, giving them front row seats to our backyards with respect to where the proposed building is to be placed. This will also decrease the value of our property. We have consulted with a realtor and they have informed us that our house will definitely decrease in value and the number of people interested in viewing the house will also decrease. I am certain the town nor the new owners will compensate us for our loss, and our property taxes will most likely rise, and this is unfair and unjust. This proposal will bring more traffic onto our street. There are children walking to and from school and bus stops, people walking their dogs, and we have an elderly woman who walks her 2 dogs from her motorized wheelchair, and more traffic may put her safety at risk. We took the time to view the additional information in the preliminary drawings that were available for viewing at the town office, and this raised some questions. The front lot line is undersized, and our concern here is that it doesn't appear to be spaces enough to allow 6 vehicles to maneuver around and vacate in a lawful manner. And in the drawing provided to the town, the proposed parking lot is hand-drawn, not measured, and drawn to scale. How is this acceptable for consideration? The land is on an incline, and with the proposed setback, it will compromise the integrity of our driveway. This parking lot will also interfere with our privacy, the value of our home, and the safety on our street. I'm certain it is with all intentions to adhere to the safety regulations for this application, but with the building so close to our house, a potential fire wouldn't have far to jump from our house to house or from a vehicle fire to the neighboring houses. We decided to consult with our lawyer and request a letter from him with his professional and analyst. The second letter we will request follow this one. To this, I would like to implore you, Mayor Murphy, and the council of Bon Charles Valley to deny this application and have it remain as an R1 zone. Please take into consideration the loss in our value of our homes that we have resided in and worked so hard to maintain and build up over the years. Yours truly, Brian and Cynthia McFarland. So I will now read the letter that was accompanied from Blair Jones. I confirm that you provided me with the public notice and the application for zoning amendment.
Dana,
Yes.
Can I just make sure that Mr. and Mrs. McFarland are all right with sharing legal opinion that they paid for? You're okay with that? Thank you. I just wanted to make sure, because this isn't the township legal opinion. This was for you guys. So thank you. Go ahead, Dana.
Okay. So I will back up as I lost track of where I was. Sorry. I will confirm that you provided with me the notice and the application for zoning amendment, as well as the planning report dated September 16, 2021, issued by N. McPhee, County Planner. In particular, you've asked me that I review the above documentation and provide my analysis of the same. I acknowledge your intent to file this letter with the municipality together with your objection to the application, and I consider to you doing so. The following are my comments. 1, the property is currently zoned R1, which zoning would allow for the construction of a single family dwelling. A review of the zoning map indicates that all of the lots along Wallace Street between Elgin Street and Raglan Street are zoned R1. All properties that abut the block of lots are also zoned either R1 or CF. I understand that there is a cemetery and a church in these CF zones. The point is to be made that there are no multiple dwelling structures abutting the lands in question, nor within the above noted block of lots. A 4-unit dwelling would be inconsistent with the designated zoning of the properties in this area and inconsistent with the use of the lands in general in this area. The owner is seeking a far more intensive use of the property than is consistent with the character of this neighborhood. 2, The lot is undersized to begin with, even when applying R1 standards under the zoning bylaw. Section 3.19 of the zoning bylaw recognizes that an existing undersized lot may still be used for its designated purpose or purposes, provided all other provisions of the bylaw are complied with. It is important to recognize through that this provision grants an exception to allow the property to be used solely for R1 purposes due to the legal non-conforming status of the property. If this lot did not already exist prior to the passage of the zoning bylaw, its creation relying on its current dimensions would be in contravene of the zoning bylaw provisions, and as such would be prohibited. To grant a zoning amendment to R2 would expand the permitted uses of a property that is already non-compliant, which is contradictory to the meaning and the purpose of section 3.19G of the zoning bylaw. 3, the lot in question does not comply with the minimum required for frontage for R2 zone lot. The zoning bylaw inadvertently omits to specifically address the frontage requirements for a 4-unit dwelling. A triplex allows a minimum frontage of 20 meters. An apartment dwelling house, 5 units, five or more units, requires 30 meters. It can therefore be implied that the required frontage lies somewhere between 20 and 30 meters. I would suggest that if the intention was to keep the frontage requirement for a 4-unit at 20 meters, paragraph 6.2b would have simply included a 4-unit in that definition. If we used paragraph 6.2c as a guide, we would also add 6 meters to the frontage requirement for a triplex, which would result in frontage requirement of 26 meters. If we took an average required between a triplex and a 5-unit apartment, we would imply a frontage requirement of 25 meters. The fact, though, that the subject probably does not meet the minimum requirement for an R2 zone using any benchmark. The property is already non-compliant for the use as a lot for a single-family dwelling. The problem is only further compounded by expanding the permitted uses. A 2.5 meter variation reduced from 20 meters to 17.5 meters is significant. If we accept that the reasonable benchmark for a 4-unit dwelling should be 25 plus meters, then the request for a frontage reduction of 7.5 meters is beyond what could be reasonably be considered minor in nature. 4, the proposed construction does not comply with the minimum side yard setbacks required on both sides of the proposed dwelling. Pursuant to the R2 zoning provisions, the minimum side yard setback is 3 meters. Based on the sketch that I received, it appears that the owner needs to reduce the side yard setback, not just to one side of the property, but on both sides. I do not believe that a 19% reduction in the side yard setback on both sides, i.e. 38% less side yard setback in total, is appropriately characterized as slightly less than the standard. The fact that the owner is trying to fit a building on this property that is too large inside relation to the minimum provisions mandated by the zoning bylaw. I note that the zoning bylaw already sets out minimum requirements as opposed to what might be viewed as appropriate or ideal. 5, the proposed amendment does not comply with the parking requirements set out in section 3 of the zoning bylaw. Per section 3DI, the parking lot shall be located in the rear yard. The owner is seeking relief to construct the parking area in the front yard. It is questionable whether the minimum parking sizes can be met in the space provided. It is fair to say that the parking lot in the front affects the aesthetics of the neighborhood and arguably creates a safety risk. Paragraph 3D II contemplates the possibility of parking in a front yard, but only if the driveway fronts onto a garage, carport, or side yard. The owner's proposal does not satisfy the requirements for an exemption. 6, site plan control is a measure available to the municipality to control development on a property that is already properly zoned. However, the site plan control is not as suitable for proper zoning bylaw compliance. If the property does not have the correct zoning designation, does not meet the minimum frontage, side yard and parking requirements, it is inappropriate to approve a zoning amendment and minor variances in a hope that inherent non-compliance can be overcome by site plan control measures. Again, with a properly zoned property, otherwise in compliance with minimum zoning requirements, site plan control measures are then imposed to ensure the proper development of the property. In any event, the owner must first address the number of contraventions that arise from the proposed construction of 4-unit apartment on an undersized lot in a single-family neighborhood. 7, I briefly reviewed the provisions of the county official plan with respect to lands designated in Article 4 as village community. In this regard, I note the policy specifically set out in Section 4.33 that states generally new residential development shall occur in the form of single detached lots created by the severance process as infilling or minor rounding out within the village area. I do not see anything in Article 4 to suggest that the construction of a 4-unit apartment in a neighborhood of a single-family dwellings is any way encouraged or recommended. 8, with respect to the provincial policy statement, the preamble confirms the importance of zoning bylaws and official plans in the implementation of the provincial policy statements. And in this case, the owner's application does not meet any of the minimum requirements set out in the zoning bylaw, and the proposed development is not consistent with the abutting land uses. With respect to suggested intensification, I repeat my comments in paragraph 7 above that the official plan indicates that the intensification in the village community designation should not take form of the severance of oversized lots to facilitate the construction of new single-family dwellings. I trust that the council will give the above facts serious consideration, and I submit on your behalf that such an analysis on their part should lead to the denial of the application in question. There is no point in signing property-specific zoning designation and establishing rules surrounding the uses and minimum requirements to be met in those zoning designations if a municipality can ignore or amend all those rules at will. The municipality should be mindful that each decision they make sets precedents for all future applications. Please let me know if your further comment or clarification is required. Yours truly, Blair Jones. I'm writing this email in response to a letter I received regarding the notice of application and public meeting to amend zoning bylaw 2006-28, specifically relating to part lots 7 and 8, Block A, Plan 16, and part lots 7 and 8, Block A, Campbell, Plan 16, Village of Eagleville, located on Wallace Street. I wish to be notified of this decision of the Township of Venture Valley on the proposal to amend the zoning bylaw related to the above mentioned property, so I maintain my rights to participate in the appeal process should it become necessary based on the decision of the township. I received photocopies of the building plans and site plan from the township office. After review, some of my concerns are as follows. What access to the rear apartments will be provided if the parking lot is in front off Wallace Street? If access is to be from the parking lot, where is the pathway leading to the back apartments? I thought code requires a parking lot for a unit this size to be in the rear lot. If this is the case, access would have to be from Campbell Street. Is this street fit for this traffic, or will need to be brought up to code? Will the building design meet all fire code regulations? Where are the landscape plans showing the slopes and elevations changing, indicating the water drainage paths? Will runoff be diverted onto neighbors? Are retaining walls required to control erosion to sloped areas? If so, where are they located? Design and dimensions. Will the current driveway meet code requirements, or will this have to be upgraded? Is there an entrance permit required for this? Would this be deemed as a blind entrance as it is on an approach to a hill crest? The parking lot seems to be very small compared to the number of vehicles it must hold. Will it pass current codes? Site plan does not allow for much area to pile snow. Will it be pushed out onto the street? Has the impact to the neighbors been considered? Surrounding property values will be negatively impacted by this development, as well as their privacy, as the upper floors will look directly into neighbors' pool areas. Is this development really in the best interest of the surrounding neighborhood? Would there be a better choices with a bigger lot for this type of development? I ask all members of council who will be voting, as well as the developers themselves, to step into the shoes of our surrounding neighbors and ask themselves how pleased they would be to see this happen next to them. Take a drive up to the road to Wallace Street and see how small the lot really is, and you will just realize how inappropriate this development is. For the record, I am opposed to this amendment of the bylaw and will appeal the decision of council should they try to pass it. Regards, David Moore. We are writing this letter to express opposition to the proposed zoning bylaw amendment to rezone the lands from residential 1 R1 to residential 2, exception 9, R2 E9 zone in regards to part lots 7 and 8, block A, plan 16, and part lots 7 and 8, block A, Campbell, plan 16, geographic village of Eganville in the township of Buncher Valley, located on Wallace Street. Zoning bylaws exist for a reason. A dwelling such as a 4-unit proposed is inconsistent, out of the character, and out of the scale of the current dwellings in the neighborhood. Not only would there be need to be a bylaw amendment to allow such a dwelling to be built, but also an adjustment variance would need to be made to the setbacks within the bylaw, which is not in itself an additional reason that the proposed 4-unit dwelling is out of scale for the current lot and neighborhood. Also, traffic and safety of pedestrians are major areas of concerns. The additional traffic will negatively impact the safety of children and students walk to school and the bus stop along Wallace Street in the mornings and afternoons. The visibility on that particular section of Wallace Street is not ideal with the rise hill in the road. It is not only vehicles using the road, but also pedestrians due to the lack of sidewalks. It would be much more dangerous for all pedestrians and drivers if there were to be a 4-unit dwelling with more vehicles on the road turning into and out of this property. If visitors were to park alongside the road, if the 6 proposed parking spots are occupied, it would add to the roadway hazard. We're strongly opposed to this bylaw due to the negative impacts the proposed rezoning would have on the neighborhood. Regards, Philip and Robin Plantagna and family. That's all I have.
Thank you, Dana. Good job. Before I go to presentations, I'll just ask what I always ask. If you sent in a letter, we understand your position, so you don't need to do a presentation. With that being said, presentation by those in support of the bylaw. Presentation by those opposed to the bylaw. Presentation by applicant or agent. Then I will move on. Comments, questions from council. And Bruce, I will open it up to you as well. There he is.
Good evening, everybody. Thank you, Mayor Murphy. So, thank you. So, as was mentioned, Anne McVeigh was a planner with the County of Renfrew. She wrote the planning report for this file, and unfortunately, she wasn't able to get tonight. But I'm trying to do my best to fill in for her. So, the staff recommendation that was attached to the planning report was that council not make a decision today and actually hold the application in abeyance and to provide the applicant with the opportunity to provide some additional information, some information that wasn't available at the first time. And that will allow staff to review the application and make some probably more different comments or more fulsome comments on the application. So typically when we see a request like this to increase density, the property is subject to site plan control. And so a lot of the issues that were discussed today are issues that site plan control would specifically address. So things like parking area, making sure that there's a safe entrance into the site based on the number of vehicles being proposed. It is at a crest of the hill. I think I heard that in one of the letters. So whether or not that entrance is safe for the number of vehicles that are being proposed, that's something that the township's public works department will have to take a look at. And also they'll want to see the design of that parking lot. So Also things such as lock grading and drainage. Where is the stormwater going to go? That's another site plan issue that once you have more formal drawings, you can the applicant's required to demonstrate how the stormwater would be managed off the site. Other comments related to things like privacy, those aren't, or property values, those aren't actual planning concerns for the township to take into consideration. Not that typically you would look at the impacts that a development would have, but the right to a view or the issue of overlook or privacy, those are not planning issues for the municipality that you'd be able to sort of have any leg to stand on if for example, if there wasn't an appeal. Those aren't any items that are considered either under the official plan policy or something that the board would consider, and not a topic or issue that I would recommend council take into consideration for determining whether or not you want to support or not support the zoning amendment. So a lot of the other issues though, with like how it fits in the character of the neighborhood, those are valid comments for council to consider. And the staff recommendation was that the applicant be provided time to go out and hire a planning consultant to prepare a planning justification report, and then also to submit that formal site plan to show how this building is going to work, how the site would work in the context of the neighborhood, and provide that information to council before you make a decision. So the recommendation would hold the application in abeyance until that the applicant is given the opportunity to come back with that information that I think council needs before you make a decision to support or not support the application. Thank you.
Thank you, Bruce. I think that's all excellent advice. And, a couple of the authors of the letters invited council to drive up and actually see the lot, because I know that some of us are not necessarily spatially good. So I know that the majority of council did. I, in fact, went up this morning, and I do see where there would definitely be challenges. So with that being said, with Bruce's advice, council, are you okay to leave this in abeyance and send the application back to the applicants for more information? And I know that Bruce brought up like a proper planner to go out and help them out. And I think that that's probably very good advice to our applicants. So I will just, Tim, I see you unmuted.
I agree with your Bruce's recommendation for sure.
Thank you. Merv?
I support it fully. I mean, I didn't take any measurements, but I just looked at the lot and my gut said, how are you going to do all this? And I'd like to see it on paper, how they're going to do all this and address the concerns of drainage and snow removal and parking area.
Well, and even fencing, I know Bruce said, that's not really in our purview, but if you're putting up a 2-story apartment building and you've got neighbors that have enjoyed the privacy of their backyards, it would behoove the applicant to do something. Brent.
Yeah, no, I think that we need to review it again, as Bruce had said. As specifically, I know on just because there's such a drastic, it's a really sloped lot, so just make sure that there's enough room for not only the snow load, but just to make sure, obviously, any private property can impact another private properties like drainage. So we just wanted to, I guess, have Jason or anyone take a look at that as well, just to make sure that it's going to be appropriate. But I guess the simplest thing for that would be just because they're asking for a setback on the sides. And I think that there would, I guess one of the questions I'd be curious on is just on why the property wouldn't be pushed back farther in the lot, so there wouldn't be any side yard setbacks, because it would generally provide more adequate space for parking, just because I know I have multiple properties that have like six parking or 10 parking, and you need adequate amount of space to safely maneuver, especially I saw in the application for some of the senior parking as well. So I think it's just kind of something to look at, just make sure that the parking is going to actually work if it is moved forward, just because it does look quite dense, especially in consideration that the snow load wasn't put on the site plan that we received. So it's just kind of a couple things like that. I think, as Bruce said, it's good for us to look at it again on a later date.
Okay, and last but not least, Jack.
Yeah, I'm in agreement that we need more information. A more detailed site plan has to be to address these issues that have already been highlighted, the parking, the drainage, all that has to be more firmed up. And also to, even though it's not something that we can really entertain, it'd be nice to know what sort of privacy they're planning for the neighbors, and if this was to go forward. So, yeah, I'm in agreement with more information.
Right, well, then we will send the applicants back off with Dana. Dana, you're good? Okay, thank you everybody for attending. We really appreciate all of your emails and your interest in this, and stay tuned. So thank you.
Jennifer, just a quick question. Do we have an opportunity to speak, any of us, or is this the end of it?
Well, that's what I was saying, Dave, is that because you wrote in a letter, we totally understand where you're coming from, and there would be, you'll have opportunity at a later date to also comment.
Yeah, because one additional comment I'd like to mention that I don't know that was taken into consideration. I know it was in a letter, that with the front parking lot, 6 vehicles is not going to work. What I fear happening is down the line, once the property is established and everything is good, should it pass, that the rear of the building would then become a parking lot, because there's 2 entrances that face Campbell Street with nothing on the site plan showing or indicating how access is gained from the parking lot to the rear of the building.
And Dave, I totally appreciate
Okay.
what you're saying, but
So-
council has made a decision to send this back, and I know that you will be getting a further letter. So pardon me?
Can we answer that question?
No, because council has made a decision. So sorry, guys, I apologize. But you will be hearing from Dana, and thank you for attending. Thanks, everybody. Council, can you all log off, please, and log back in?
Give me a call, John Joe.
Sounds good, I will.
All right. Thanks, guys. Thanks, everybody.
Thank you so much, Bruce. We really appreciate it on
Thanks,
such
Bruce.
short notice.